Happens as well, but I only did it two. And then before for each. Maybe the boy, I like. the
Yeah.
boy ways.
Good afternoon, Judge.
Good afternoon.
This
How's
is
it?
my mic so I can hear you better.
All right, thank you.
From downstairs up?
Yes, we're gonna need, I think there are a couple of pleas, so if we could get the pleas done. And then I need Edgar Aguilar, Joe
Yes.
Jimenez. Those two, yeah. And Norma, if you can make sure that Mac is here.
For tomorrow?
No, today, on the Joseph Grant, not Joseph Grant, I'm sorry, on Plickton.
Sean, is that Sean Clinton?
It's Scott Hill on Plickton. On Aguilar,
Yes, ma'am.
what, 30 minutes aside for jury selection?
Yeah, and we're gonna go to you for punishment,
Okay,
so,
all right. You all want a bench trial?
I mean, we'll discuss it with the client.
All right,
I don't think so, but we'll discuss it.
all right.
He's not here yet.
He's inside.
Yeah, we have. No, he sits on this side.
With the bicycle for when he comes back.
Perfect.
See you in it. I know.
You're not starting yet, there's a 15.
Oh, okay. What does that mean?
I'll let you get to the. I'll let you know.
Okay. No.
They're not ready on that, that's coming on under the day.
That's solid.
Oh, they're bringing him out.
Which I was saying was you.
Sometimes you gotta go.
Infections posting online.
Sometimes you gotta go. Let's see.
There's more problems. They won't give her a monitor because they say she's not GPS eligible and they still have her in the jail. I mean, I don't know what I can do at this point.
Hi.
I don't know what that even means. It's a judge's order. Mhm. I'm so sorry. I need I'll go and try to, I don't know. I mean, if she's sitting in jail, she's not gonna be having her monitor, so I need to.
From where? What do you mean she doesn't talk about? All right, I'll take care of it.
Yes. He lives in the same.
Yeah.
I know that's.
Oh, so you think it's yes. Same person. I was secretary of the 290. I don't let Ruth, Billy's getting.
But I will tell you,
Other places, how do you have? Yes, okay.
Not if they don't come right now. There goes, yes, he's not here.
So.
I think you will. Yeah. I think.
We have to send the points.
Yeah. Quite sure. Yeah. Yeah, I don't. I wouldn't.
What we do.
Sure. Yeah.
Or I'm sure someone. Yes. Okay. Yes.
Oh, yeah.
It doesn't just. Take it on top, you know? Gentlemen, bottom row. Everybody over here? Oh, my person wants to find. Make sure you go in and check in.
I have read one to settle the bond production because, you know, it'll take 5 minutes total.
Oh, and score was one.
Yeah. So bad, Rippin. Yeah. Especially.
They were ready. I mean, it's ready.
I'm sitting there, he goes. Good. Interesting, that was not what I was expecting on this level. He was very pleased in ways that I wasn't expecting, so it was- We gotta work this out. It was actually very reasonable. Like, oh,
Thank you.
All right.
All right, everyone, please be seated. No, this is. That's why I missed it. Oh, here it is. Okay, all right, so let me, now I gotta redo this. No, it's in March.
I made an appearance on this case.
One is civil.
All right, Darren Doe's. And is this only gonna be on one case?
I think it's going to take up, or actually all.
All right, court is calling 2022 CR 0493 State versus Darren Doe's. Could I have parties announced for the record for the state?
Ashley Jones for the state.
Defense.
Surgery bar for Mr. Dose.
And are you Mr. Doe's? Counsel, have you received all discovery? Did you review it with your client?
We have, Your Honor, and we have.
Court will find that the state is in compliance with discovery. Mr. Does, did you review the document titled Application for Community Supervision with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are not, Your Honor. We are going to proceed on count one, which is assault, serious bodily injury, and waive two.
Any objection?
No objections, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand your charge and count one with the offense of aggravated assault causing serious bodily injury as a second-degree felony? Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand? If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, ma'am, I do.
Mr. Doze, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
And did you understand, Mr. Kalfas was here this morning, however, Mr. Kalfas had to leave. Do you have any objection to this attorney standing in?
No, ma'am.
All right, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on count one. Punishment is to be assessed at 8 years in the prison. There's a $1,500 fine. There's no application for deferred adjudication. State recommends community supervision. They're taking in consideration 2022 CR 0494. There's an affirmative finding of family violence, and there is to be no contact with NECRA, NEKRA, Doyle, DOYLE. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
Did you understand that to be the entirety of your plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor, if I could make one clarification on the no contact order, it should be NECRA, NEEKRA.
All right. And so other than that, that's your understanding of the plea?
Yes, sir.
All right, did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there been any such motions?
So many.
Outside the agreement, the state is requesting that your community supervision be for a term of 8 years. There be 150 hours community service restitution, BIPP, TAP evaluation, coping with anger, and cognitive behavior course. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to count one, how do you plea?
No contest.
State any evidence.
State offers States Exhibit 1 and all attachments.
No objections, Your Honor.
All right, and have you spoken with the person with the no contact order?
We have, Your Honor.
All right, you may be excused.
Thank you, Your Honor.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, this was a case that we had a lot of back and forth on. There were some strong defenses in this particular case, but we do believe that this agreement is in the best interest of justice. So we ask that the court respectfully that the court follow the plea agreement.
All right, are you employed?
Yes, ma'am.
What do you do?
I'm a server at a restaurant.
Do you have any children?
No, ma'am.
Do you live by yourself or with someone?
By myself.
And if you're drug tested today, what would the results be?
Next.
All right, the court will sentence you to 8 years in the prison, suspended and probated for 8 years, $1,500 fine, probated, taking consideration 2022 CR 0494, affirmative finding of family violence. There's to be no contact with NECRA, NEEKRA, Doyle. There is to be 150 hours of community service restitution. This coping with anger, shouldn't the BIPP address that? Or is there something he needs more than that?
Your Honor, I do believe in this case, there was one that was family violence because of domestic relationship and one that was family violence due to a familial relationship. And so the state just wanted both courses to address each of those issues.
All right, the court is going to order the BIPP course. The court is going to order. All right, so here's the thing with the coping with anger. I've read the police report. I know that there are other things that were at play in regards to this. Do you need help coping with your anger?
Oh, man.
All right, so let me just explain something to you. If you come before me again, because the BIPP addresses anger issues, if you come before me again and it's something related to anger, we're gonna have issues. You understand?
Yes, ma'am.
Ms. Abrams, this coping with anger, if he takes the BIPP course, would that address those issues? All right. And then the cognitive behavioral course. I mean, what is that, to change his way of thinking? All right, I'm gonna order the cognitive behavior course. And once he completes that, 100 hours of community service restitution will be deemed satisfied, but you'll have to complete the other 150. There should be regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days. There should be no employment as a home health care provider or with minors. There should be field visits 1 time per month for 6 months. Probation, is there anything else? Is there anything else you need from the court to be successful?
Actually, Your Honor, if I may address that, this may be the appropriate time.
Yes.
There was Mr. Doe's, because of the cases that have been pending, had diligently been looking for employment. And currently he's working as a server, but it's been very difficult for him to find employment substantial enough to pay off the GPS fees that have accumulated in his particular case. I think he has something on the order of $10,000 in assessed fees from GPS. If the court has any ability to give some consideration on that, or to allow some portion of that to be waived, I think it would help him to be successful on this.
Oh, I have no authority to do anything with regards to the GPS because it's with a third-party contractor. So there's nothing I can do with that. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, and also because this is an affirmative finding of family violence, you're also not allowed to own or possess any weapons or ammunition. All right, probation will go over conditions with you. And once she's gone over those conditions, you are excused. To be successful in this court, communication is key. If there's an issue, let your probation officer know. If you feel as though they're not addressing it, you can always come back to the court.
Thank you, Your Honor.
All right, thank you.
Your time, Judge.
You're welcome. Allison Settle.
Correct.
And Megan and John, if you can make sure that you filled out the jury, I'm sorry, the election of punishment. Yes. And if y'all can also make sure I have an acknowledgement of discovery. I think I do, but just to be on the safe side. All right, where are we on this case?
So Judge,
We conferred last week. I've got all the discovery that I think I'm entitled to.
Okay.
The reason the case is back before you today is I filed a motion for a bond reduction hearing
Yes.
on the cause, the last two numbers of the styling being number 90.
Yeah.
On possession or unlawful possession of a firearm by a felon. By way of proffer, Judge, asking for the court to reduce the bond in that case. It's set at $20,000.
Okay, let me go on the record with that. Has an offer been tendered or no?
No off the object.
Okay. All right, the court is calling 2024 CR 013090 State versus Allison settled. Can I have parties announced for the record for the state?
Folks, look at the pen, Judge.
And are you Ms. Settle? All right, state, are you ready to proceed on the motion requesting bail reduction? Yes. All right, do you all have an agreement or no?
No, Judge, the state is in opposition for reduction.
All right, then defense, do you have any witnesses?
No, Judge, just proffer for you if I may.
All right, yes, you may proceed.
So Ms. Settle currently under indictment for two causes, Judge. Other cause of bail set at 7,000. This case, the bail is set at 20,000, Judge. She's asking the court to consider reducing that. It's beyond her ability and her means to make bonds in the total amount of around $20,000, Judge, which I think is about $7,000 less than what you're set right now. The court can see she's pregnant. She's scheduled to have a child in 4 to 6 weeks. So her request for that reduction had something to do with that, Judge. She doesn't want to have the child in custody. I certainly understand the court, the state's concerns with the nature of the allegations. The state will tell you that there's some criminal history, Judge. But we're asking for the court to reduce that bail amount. Antonia is her community and her home, Judge. Her ties and her link are here. I don't know about attendance in any previous cases, but she's been in custody for the duration since she was arrested on these cases, Judge. If the court is inclined to reduce the bond, wonderful. She does have somewhere to go. Someone would be helping her out, putting her out as far as a place to live goes. I know sometimes the court has concerns about individuals housing folks when they're out on bail. So if the court's not inclined to allow that, I think there's somewhere where the court has ordered folks in the past to be able to go have the child. And it's it might be treatment facility as well. Possibly, yeah, perhaps, Judge.
Okay. All right, state.
Yes, the states are opposed to the possession. Of the biggest reasons, I mean, one, freedom, safety, which in charge was including allegedly from her own family. And then on top of that, Judge.
I'm sorry, wait a minute, you just said allegedly what?
Her own family, her victim.
Okay.
That she could not go back to that house, which is her mother's. And then on top of that, the possession of many different items, including in this particular case, a handgun. And then on top of that, safety of the unborn child, she does have a history of substance abuse and allegedly the mother has said that she's still possibly used. So the state's position is $20,000 is sufficient for the community and also for the child.
All right, this is what the court is going to do. The court will deny the motion. Court will alter and amend conditions to full GPS and waive GPS fees. All right, we're off the record. So with regards to the offer stage, I know you haven't tendered an offer yet. So when do y'all want this brought back?
Judge, we haven't asked for one. I've asked my client to tell me if that's something she'd like me to do, consider that. So we have a regular reset for that purpose. And then I can-
All right. Ms. Ferguson, if I could get a 30-day reset on settle.
Judge,
Uh,
Sorry, that would be March. The 20th.
All right, so we're going to come back on March 20th. State at that time, you need to be prepared to tender an offer. Counsel, if your attorney wants you back sooner, he'll let us know.
Thank you, Judge.
All right, thank you.
Dr. Mack is here.
All right, let them know about Mr. Hill. Walter Davis. Court is calling 2024 CR 009355, State of Texas versus Walter Davies. Could I have parties announced for the record for the state? Defense?
The attorney of record is Monica Guerrero. Joseph Stateson standing in. Mr. Davies, will you give this judge permission for me to do this in case of Ms. Guerrero?
Yes, I will.
All right, counsel, have you received all discovery?
Yes, Your Honor.
And did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Davies, did you review the application? Is there an application in this case?
Yes, for regular probation. It was
All right.
filled.
Thank you. Did you review the application for community supervision with your attorney? Did you understand it and sign it? Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented? Any objection?
None.
All right, did you review the court admonishments with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand that state is proceeding on possession of a controlled substance, penalty group 1, 4 to 200 grams? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent? Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is, Your Honor.
Mr. Davies, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promise you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, the state is proceeding on count 2. They're asking that your punishment be assessed at 3 years in the prison. There's a $2,000 fine to be probated. The state recommends community supervision, and the state will take in consideration 2024 CR 009339. Did you understand that to be the plea? Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there being such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 3 years. There'll be a TAP evaluation and 200 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to the offenses charged in count 2, how do you plea? Guilty, not guilty, or no contest? State, any evidence?
No objection.
All right, and state, do you have the dismissal? Did you review the waiver and consent with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
All right, anything you wish to say on behalf of your client?
Judge, we wish that you would follow the recommendation. He's eager to start probation. He's been on bond awaiting this for about 9 months, with about a year. To our knowledge, there weren't violations. He didn't know yesterday. He had a medical appointment previously and he got perhaps a day mixed up, but he came to court when he missed work. We asked that he follow the recommendation.
All right, what is your relationship to Monica Pittman?
None.
How did y'all end up at the state jail facility?
She asked for a ride.
All right, was this just somebody you picked up?
No, I live on a piece of property. I paid the taxes on a piece of property and her boyfriend went to prison and she started locking me out and I've been there for 2 years, so there's no relationship. Other than she was taking responsibility of that property, I guess. And it
Okay.
wasn't her property.
All right, do you live with anyone?
No,
All right, are you back on your property?
that property, it's unlocked. She was locking it and not letting me in. I called the sheriff's department several times and they told her she couldn't do that because my trailer's been there for 2 years. So they had 3 years to pay me back my taxes on the property. I've got another year.
All right, and how often have you been using?
Forever, but I've been clean for a long time.
Okay,
See,
all right, so how do you maintain your sobriety?
by not using.
Okay, well, that's good. So you don't go to any type of classes or anything of that nature? All right, and are you employed or retired?
I'm retired. I get a social security check, but I play music. I'm a musician.
Okay, all right.
So I make some extra income now.
Okay, all right, the court is going to find you guilty, sentence you to 3 years in the prison, suspended and probated for 2 years, $2,000 fine, that'll be probated. Take in consideration 2024 CR 009339. There's to be no contact with Monica Pittman, Pittman. Regular reporting by Zoom or in person, regular random UAs, and I'll recall the warrant. And there's to be field visits 1 time per month for 3 months. And we can do a TAP evaluation out of custody. All right, probation, is there anything else? Yes. Proof of SSI within 45 days. All right, is there anything else you need from the court? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, thank you. And Deputy Laura, he can be released.
Thank you,
Thank
Judge.
you.
All right, thank you.
Good to see you again.
Oh, you too. And thank you. Always dress appropriately for court. I really do appreciate that.
Thank you, Your Honor.
All right, you're welcome. All right, anyone else has a plea ready?
Yes, Judge, I had turned in before the break, Justin Galena
All right, can I
we're
see
ready.
Justin Galena, please?
on MTR.
No, I don't. I turned him back into you all.
Your Honor, may I approach when you have a moment?
Yes.
Just have a dismissal.
Sure.
Thank you.
All right, and Deputy Laura, if you have Nicholson, he can be brought. Ah, so Mr. Nicholson, they're gonna dismiss the other case, okay? All right.
Yeah. Yes. I don't know. if it's actually- So she could go back, Nicholson?
Yes.
Your Honor,
Yes,
may family violence be excused? We don't have any other cases on the docket.
sure.
Okay, thank you. Judge.
Leaving people behind, but that's okay.
Yes, Judge.
Good luck, Mr. Nicholson. Okay, thank you. Mr. Statesman, we're ready on your. Oh, that's up to the attorney.
Okay, I just didn't know if it was anywhere.
Yes. Court is calling 2021 CR 11622, State of Texas versus Justin Galena. Could I have parties announced for the record?
Joseph Stateson for Justin Galena.
And are you Justin Galena?
Yes, ma'am. Yes, Your Honor.
All right. All right, Mr. Galena, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
I did, Your Honor.
Are you the same Justin Galena who's placed on deferred adjudication in 2021 CR 11622 for the offense of possession of a controlled substance, penalty group 2, 4 grams to 400 grams on May 25th, 2023 for a period of 4 years? Is that you?
Yes, ma'am. Yes, Your Honor.
All right, state.
Day of March 2024 in Bexar County, Texas, defendant Justin Randall Galena committed the offense of driving while intoxicated in violation of condition number 1.
How do you plead to that? True or not true?
True, Your Honor.
State waives the remaining violation allegation.
Any objection?
No objection.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to a $10,000 fine?
I do, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 1? Court will find violation of condition number 1 true. Is there a proposed agreement?
So,
That is correct, Your Honor. However, I did speak with ADA Garahan, and he was going to allow us to ask for outpatients. And that the state's recommending SADF, that's their position. They would not agree to something other than SADF. And if we could ask for you to choose what happens. I know it's your prerogative to determine what happens regardless, but if I could proffer reasons why.
Sure.
Your Honor, Justin picked up a DWI March 2024.
Mhm.
After that happened, he was arrested. There's a slew of about 3 or 4 months of no shows for urine testing.
Mhm.
Previous to that, he was testing regularly every week. He missed one test. And there's dozens and dozens of negatives. Early on, there were marijuana. I think there were 2 diluted, but the significant part was just a consistently negative. It's not often you get somebody who pays a lot of their fees.
Mhm.
He paid significant portion of his fees.
So here's my question. What does the TAP recommend?
I don't know if the TAP recommendation had SAT-F on there. I'll have to check.
Yes.
Judge, the TAP recommendation the TAP will need to be redone. The TAP class is conducted in October of 2023.
All right, I'm sorry, go ahead.
I'll tell you what it recommends. committed at that time.
Yes.
And Chair, supportive outpatient treatment must be waived and cover support.
All right. I'm going to deny the motion. I'm going to alter and amend conditions to include an updated TAP in custody. Follow recommendations of TAP. There's going to be 120 sober meetings in 120 days. Is there anything else from either side?
Your Honor, just so I can clarify, it's not reset for sentencing, this is sentencing.
Yeah.
I'm sorry, what did you
No.
hand me?
I'm sorry. Did I hand you this? Because he's been, yes, pass that back to me, please. I'm sorry. He's being continued. So I'm denying the motion, alter and amend conditions to include a TAP evaluation that's to take place in custody and follow all TAP recommendations. And there is going to be 120 sober meetings in 120 days.
And yes, Judge, I understand now. And Mr. Delana did request to transfer probation to Dallas County. His grandmother has stage 4 cancer in Dallas. Is it Dallas County or Dallas area?
Dallas County, yeah.
Dallas County.
All right, I will consider that after I find out what the recommendations are from the TAP evaluation.
And he's going to remain in custody. He's going to enter a plea on a misdemeanor DWI in out of county court 9.
Mhm. All right. So once we see what TAP recommends, then I will make a ruling on whether or not he can transfer.
Thank you,
You're
Judge.
welcome. Yes.
Yes, probation.
Oh, yes, you.
Don Plickington. And where is, yes, hi.
So we spoke with the client and I know that he wants to speak to Mr. Hill before he decides to take any type of plea. But he also let us know that he's been having issues with Mr. White and he feels like he's being pressured into.
Oh, so here's the thing. I'm not going to address the other attorney issue
Okay,
unless you all want to address the other attorney issue.
so we think that it probably in the interest of the client to possibly just reassign all the cases to Mr. Hill. And if he could, I know Mr. Hill is not available today, but if maybe the case could be reset so that we could also reassign those cases.
All right, so I'm going to recall this case for Norma. Put this case back on the docket for February 24th. All right, thank you. We'll
you,
see you back on
Judge.
February 24th.
Thank you.
You're welcome.
Good to see you, Judge.
You too. Have a good one. All right, is there anyone else ready with their paperwork? Because otherwise, we're going to take a break. We're bringing a jury in and we're starting jury selection.
Oh, today. Okay, the docket. I'm sorry. I have the case number.
All right, defense on Aguilar, if you all want to go ahead and set up, you can.
Yeah. Judge, can I inquire? It's super brief.
Sure.
They're gonna print out a docket page for you. I have a client on bond set Thursday. I will be in Wilson County that morning and I fear I will be there all morning.
Is it a county court case that you're in Wilson County?
Wilson?
I'm just.
I think it's both, actually. Yes, felony and misdemeanor. I'm just asking to get recalled for 1 week. He's on bond.
Okay,
It's a plea deadline setting.
okay,
Is that okay?
sure.
Okay.
Once they give me the information.
Thank you, Judge.
You're welcome.
It
All
is.
right.
it's district.
It can come back the 18th
Okay.
or the 20th.
Well, you're asking.
Mhm.
Uh, 20th is better.
All right. Okay.
State's not a paid Dutch out of it.
Okay. All right, Norman, this is coming back on February 20th. Thank you.
Okay, Judge. Yes, thank you, Norma.
Judge, get a
Hello.
moment.
Yes,
What do we do with the other case that was set for trial?
just give me 1 second, okay?
Okay.
Oh, just have a seat.
Okay.
With you.
I've been here since 9
I
o'clock.
understand. I
And
understand.
Judge, I mean,
I understand.
I just asked the court also be respectful of our time. I mean, you need us, we're here to do trial. The judge, I literally have been sitting here since 9 o'clock. I have a million cases to work on.
Yeah.
I mean,
All right, just have a seat. I will get with you all.
Pretty cool. But they're like square. Just go to Goodwill. Whatever.
All right, and Megan, Megan. You. Megan Enriquez. Hi.
Yes. Sorry.
Oh, no problem.
Yes.
All right. So, who's the prosecutor on this case?
Ms. Galloway.
All right. Galloway? Hi.
Oh, I'm sorry, Judge. I thought you said negative.
No, no, no.
Sorry.
She did, but then she said Galloway.
All right.
She called us both.
So each side, 30 minutes.
That's
Yeah,
fine.
And my understanding is court, if it gets to punishment.
That's correct.
And could I see the file on Aguilar, please? And are y'all proceeding on the 09 case?
Yes.
All right. And it's 3 counts of aggravated assault with a deadly weapon?
Correct.
And are you proceeding on all counts? All right, and is your client's out here?
Yes, Judge.
All right, I think they'll probably need to take him in back to fit him up.
Okay, so the ladies from the MAC are going down to the 226 to get some shoes for him.
Ah, okay.
Yeah, they'll be right back.
All right, thank you.
Thank you.
All right, could I see the remaining cases, please?
Yes.
Who's the attorney on Leo Cantu?
I am good.
And where's Mr. Cantu?
He is.
Hi, Mr. Cantu. All
they couldn't bring him on.
right, Mr. Cantu, come over, please.
Actually, Judge, if we have a minute before we have direction.
Okay, sure.
Video with them.
Okay,
Well, I guess we can do an announcement, Judge.
all right, what do you,
I think it's the first setting, Judge. I've got discovery. The state tendered an offer. I'm gonna go through some discovery.
all right, when do you want it recalled?
Whatever the first preference.
No, I mean, Do you want 30 days? Do you want less than 30
I
days?
could have 30 days, and I think I got March 20th.
Okay. All right, Norma, on Cantu, place them for March 20th. And that will be your plea deadline date? Do you have, all right. All right, so your plea deadline date will be March 20th. And on that date, you'd have to let the court know if you reached an agreement with the state or not.
This month.
All right, thank you.
Yes.
Thank you. Thank you very much.
We've got a couple of our interns here. Can they watch jury selections?
Sure.
And where would you like them to sit?
They can sit in the jury box if they want to, or sit over there, or sit next to you all.
Okay.
Just need to look at some more chairs, Judge. No? How many do you need?
How many do you need?
How many more chairs?
Who's here on Caroline Brown? Yes, what is happening?
I'm talking to her and confirming with the state.
All right, Ms. Brown, if you come up, please. Hello. Oh, no, I understand. So have you received all discovery?
At this point, I'm trying to determine that, Judge. I haven't been able to ask the
Okay.
state.
All right, Ms. Ferguson, Ms. Brown, if you'll give me a 30-day reset for discovery, and if your attorney wants you brought back over sooner, he'll let us know. Okay. All right, we'll bring you back on March 20th. Thank you. Richard Campos. Who's the attorney for Richard Campos? All right, and where's Mr. Campos?
He's coming.
Hello, Mr. Campos. So you're scheduled for jury trial, but we're actually starting jury on this case. So I'm gonna put you on call, and I'm gonna put you on call for tomorrow. And then if we're actually in jury trial and this hasn't been concluded, you'll receive another date.
You mean this evening, Judge, or?
Yes.
Okay.
So Ms. Ferguson, they're on call for tomorrow.
Okay.
All right.
Just leave my contact number with Ms. Ferguson?
Yes.
Aguilar.
Maybe, excuse Judge.
After,
After.
yes.
Yep.
Jimenez June. Ms. Settles Brown.
Joe Anthony Jimenez. Who's the attorney for Joe Anthony Jimenez? Hi, is your client in custody? All right, he'll be on call. We'll have him, Norma, have him recalled for tomorrow. They'll bring him back tomorrow. Yes. Just call in. All right, thank you.
That's been okay for a Walker Street
Yes.
reception.
Marino Rendon. All right, Mr. Rendon, you're on call for tomorrow.
Yes,
Okay. All right, thank you.
Just let the court know, I've got to be in Palmdale County as well as Bear County, so I'll be back and forth
Okay,
between the two, but I will call in the morning.
thank you. Matthew Rendon.
Sure.
All right, counsel, you're on call.
Judge, do you actually need him here?
Hmm?
You want him actually to be here?
Yes.
Okay.
So he'll be on call and just come in the morning and we'll know whether or not this trial has worked out or not.
Okay, thank you.
You're welcome. Araceli Robles.
She's the lady that was in, she said we have.
Yes, and my understanding is that you all were speaking to the state.
I did confer with Megan, or Victoria did this morning, and she said once she's released from there, we will try to incorporate these new cases with what she's on probation for.
There is one pickup, Your Honor, which is that as far as I can tell, Catherine Valenzuela is the attorney. of
Yeah,
record.
I looked at that, Judge. We're still trying to sort that out. I could have sworn I was on all of them, but we'll figure that out.
All right, so counsel, you're gonna be in the building tomorrow?
Yes.
All right, stop by on Araceli Robles so we can figure everything out. And Norma, if you can see about the other attorney who's also on that, if they can come by.
I spoke to
tomorrow.
her this morning, Judge,
Okay.
and she's aware that I'm trying to fix it. I did find the reset and it had my name on it, so I thought it was mine.
She has 1, 2, 3. One is a motion to revoke.
I think that motion revoke's been resolved, the other ones
Yes.
have not.
And so she has the 2 other cases, which if you could have them pull those cases, because I don't have them. And who is on Anel Soto Figueroa? Come forward. All right, counsel, you're on call.
Yes, Your Honor, may it be available and reachable through text. I know that she has to work, but we can come here if necessary upon receiving word from the court.
Yes.
Thank you, Your Honor.
All right, thank you.
Have the excuse, Your Honor.
Yes. And I need them back, I mean, the,
Can you move it how we have it in the last trial?
is the cart gonna work if you move it? We do not know.
Oh, okay.
So, yeah. All right, and do you have the mouse? We never know if this equipment is gonna work. You've been here long enough to know the equipment doesn't work half the time. Yes, yes. And counsel, if you're removing your information from the screen, have you moved it? Ah, okay, all right.
I'm trying to get these people.
I know you've been.
Sure.
Yes. The little brown Peter Pan shoes, but they were his.
You can make sure the numbers are correct. They are. They are. Oh, okay.
I get left you, let me move these around. How about that? Yeah, after today, I need a vacation.
Okay. I am right there with you.
Very strong.
I called it. All right. Is calling. Okay. All right, court is calling 2023 CR 4709, State versus Edgar Hernandez Aguilar. Could I have parties announced for the record for the state,
I think Galloway and Jason Garrett for the state.
for the defense? And are you Mr. Aguilar? All right. So we have an interpreter. If you could raise your right hand for me, please. Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God? All right, you can lower your hand and have a seat. Counsel, my understanding is that a private immigration attorney was hired for your client. Is that correct? All right, thank you. And are both parties ready to proceed?
Also,
All right, thank you. And are both parties ready to proceed?
State's ready.
All right, each side will have 30 minutes for voir dire. Let's bring the jurors in. Okay, all right, thank you. Well, what I can tell you is when you're speaking into it, the only person who can hear that is the court reporter. Nobody else can hear. Oh, no, she's not. No.
Talking to us.
No.
Yes, no, yes.
All right, any objections to proceeding without juror number 20? Oh, I'm just having you all discuss that we're going to put it on the record. So to both parties, juror number 20 is missing. All right, we're going to go on the record. The deputy has told me that juror number 20 is not outside. Any objection to proceeding without juror number 20? State?
No objection.
Defense?
No objection, Your Honor.
All right, deputy, let's bring them in. And I'll put it over here.
Take a room. Guys can have a seat. You're gonna need your numbers. Not the number, you need it.
Oh.
All right.
All right, everyone, please be seated. All right, everyone, good afternoon. Oh, that is such slow reaction. I know everybody probably had lunch and you've been waiting out in the hallway and downstairs, and everyone has been telling you to hurry up and wait. So, good afternoon, everyone. Awesome. All right, so I do appreciate the fact that you all been waiting a long time, I see some of you when you run across the street and you're supposed to be here at 8, and I always tell you to slow down. It's hurry up and wait. It's sort of when you go to the doctor's office and they call your name and you're excited because you think you're going to be seen, and then they put you in that room to check your blood pressure. So that's what happens here sometimes. What I want you to know is that in this court, even though we are scheduled for jury trial, I do have a full docket. So the fact that you all have been waiting outside or were waiting down stairs is not due to any of the attorney's fault. It's just that we have a large docket. Usually I have about 60 to 70 people on the docket that I have to take care of. So that's why you're here at this beautiful time with all of us. So you are in the 187th District Court. We're located on the 4th floor, and I'm Judge Stephanie Boyd. So what floor are we on? What's the court number? And who's the judge? That's the first time people have said my first name with my last name. Now, you probably ask yourself, why on earth is she asking us this? She needs to move it along. We've been waiting. The reason why I ask you that is because sometimes we'll take a break, and whenever we take a break, lo and behold, people get lost. And we've had instances where somebody's been trying to go to another jury room because they don't remember this jury room. And it gets confusing if you're not downtown on a regular basis. So if you're ever lost when we take a break, if you just say 187th or either Boyd or Stephanie, I'm the only Boyd in the entire courthouse, so someone will be able to direct you where you need to be. So I want to have the parties, because this is a state of Texas versus Edgar Aguilar. Could I have parties introduce themselves, please? State.
Megan Galloway.
And Jason Garahan.
Good afternoon, I'm Megan Enriquez.
Hi, I'm John Coons.
And Mr. Aguilar, if you'll introduce yourself.
I'm Edgar Aguilar.
All right. So you all will notice that when he stood up to speak, there's someone who interpreted what he said. So I think languages are beautiful. I went to law school and graduate school with people who spoke 4 and 5 languages. I'm originally from Louisiana. People can usually tell because my accent comes out when I have to say words like all and soul. So I thought I was going to be living in Louisiana, and I thought I would be retired at 21. Here I am, 22, and I'm still not retired. So I decided to take French, even though my best friend told me, Stephanie, we should take Spanish. I said, never going to need it. I'm going to speak my French, and I'm retiring to France. So why would I need Spanish? Well, here I am, and I'm trying to learn the Spanish language. So legally, when someone feels more comfortable in speaking in a different language, we will have interpreters to translate for them. Because if you can imagine, if you were to go somewhere and they were telling you, you know what? I know English is your first language. You're just going to have to deal with it. We're not going to have an interpreter to explain all of this legal technology to you or legal terms. You're on your own. In the United States, we don't do that. Everyone is entitled to have a fair trial. And part of having a fair trial is actually understanding the words that are being spoken at your trial. Does everyone understand?
Yes.
Right. Is there anyone going to hold it against Mr. Aguilar because he has an interpreter? Thank you. And we do have the interpreter. If you will introduce yourself. Yes. Thank you. And I will tell you, the interpreters here in Bexar County, sometimes they speak 4 and 5 languages. They've tried to teach me a little bit. As far as Spanish goes, I say de nada very well. So what I want to let you all know, when we have an interpreter, regardless of what you may hear people say, and you may say, well, I speak Spanish. Let me tell you what he said. Legally, that is not supposed to happen. So however you're thinking you're hearing the Spanish language, if it is spoken, the only person who is allowed to tell you what the person is saying is the interpreter. So you go by what the interpreter interprets in the English language. Does everyone understand?
Yes.
Is there anyone who cannot do that? All right, in this court, I always have students, they'll come in. Sometimes attorneys will bring their interns in with them so they can watch jury trials and learn about our legal system. Through this door, you have people coming in. It's for me to sign documents, or it may be people from the staff of the 187. It has absolutely nothing to do with this trial, what I'm signing. It's just, this is the door they come through. This door, you'll have people come in, and they're coming in because they don't see the sign on the door that says, we're in jury trial, please do not walk through this door. So they are not involved in this case either. But we do have 2 interns that are with the defense. If you could stand and introduce yourself. All right. Now, all of the parties that have been introduced to you, does anyone know any of those parties? If you do, if you would raise your number. All right, number 9. Anyone else? All right, so thank you for raising your number. And what I can tell you, all the cards you have are very important. If there's anything you need to say to me or say to the defense or the state, please raise your number and wait for them to call on you. Okay, this is very odd. All of you all bunched up in that corner. The first row, you all are bunched together. You don't have to, I mean, you know.
We're missing a person.
Oh, okay. All right. So just raise your card if you have a question. Or if you have an answer, just raise your card. And the other thing is the court reporter who's sitting to my left takes down everything that everyone is saying. So speak only one person at a time. So let's practice a little bit. So if everyone could please raise your card. And hold your card up until I ask you to lower your card. All right, jurors 1 through 21, if you could lower your card. If you still, 22, don't lower your card. I said what, 22, raise your card. If your card is still held up, which it should be, if ever there's a question that you need to respond to, if you can, I'm going to ask you to stand because the acoustics in this courtroom are horrible and the court reporter needs to hear everything that everyone is saying. What I can tell you is we've had so many jury trials in this court and not a single jury panel has been able to follow that instruction. I'm going to tell you what I tell them. I have faith in you that you will follow that instruction. So you can lower your cards. Now, juror number 9, who do you know? All right. The fact that you know Attorney Enriquez, will you still be able, if you're selected to be on this panel, to listen to the evidence? All right. Thank you. All right. The charge in this case is aggravated assault with a deadly weapon. Now, when either party talks to you about this case, they're going to speak in hypotheticals. So whenever they talk to you, do not think, oh, that's what this case is about. Because the only thing they're allowed to tell you what this case is about is what the charge is. That's it. They're not allowed to tell you what they think the facts are. You will only learn what this case is about if you are on the jury. Does everyone understand?
Yes.
So don't in the back of your mind think, oh, okay, this is what this is about. Does everyone understand?
Yes.
Now, I want to talk to you about the indictment. What is that? An indictment is just a piece of paper, and it's a piece of paper to tell somebody, this is what you're charged with. This is where you need to be for trial. It is not evidence of guilt. It cannot be taken for anything. Does everyone understand?
Yes.
All right. How many people here, raise your card. How many people here have ever had a traffic ticket of any type? All right. So one thing about Bexar County, we continue to have a lot of bad drivers, but that's okay. You can lawyer. I've had a traffic ticket before too. So let me give you an example. Let's say you're driving and an officer pulls you over and that officer says that you ran a red light. Back in the day when I had my traffic ticket, they had the little paper books. Now I think they give you a printout. Well, when that officer says that you ran a red light and he gives you the ticket, your accepting of that ticket is not saying, yes, I ran a red light. Your accepting of that ticket is so you'll know what you're being accused of and where you need to be to answer for the charges that you're being accused of. But it's not evidence of guilt. So in felony courts, felony criminal courts, the way cases come to us is through indictment. But you are not allowed to consider that indictment as evidence of anything. Does everyone understand?
Yes.
Is there anyone here who's going to hold it against Mr. Aguilar because he's been indicted? If you are, raise your card. Now, presumption of innocence, everyone is presumed innocent. Everyone has a right to remain silent. Have y'all heard of these concepts before? Where are my paper chase people, my Berettas, my Mannix, my Barnaby Jones, the practice, the good wife? All right, so the right to remain silent, what does that mean? That means that you don't have to testify if you're a defendant. I've been a prosecutor, I've been a defense attorney. Sometimes as a defense attorney, I would tell my client, it's completely up to you whether or not you want to testify or not, but the state has not proven its case. There's no need for you to testify. Or sometimes I would have clients who would be so nervous, I would tell them, this is not going to look good. You're too nervous. People may think that you're guilty just because you look nervous. The key to the right to remain silent is you can't hold it against anyone. You cannot consider it. So if a defendant decides not to testify, you can't consider it. You can't discuss it. You can't be like Mrs. Kravitz from Bewitched. Does everyone understand? Is there anyone who's going to hold it against Mr. Aguilar or consider it if he decides not to testify? Okay, because I know sometimes people will say things where they'll say things of, well, if it was me, I would do this or I would do that. And I would always tell people, but it's not you and you're not in that position. Maybe you wouldn't do it. The other thing is burden of proof and presumption of innocence. Everybody who's charged with an offense is presumed to be innocent until and unless the state is able to prove its case beyond a reasonable doubt. So right now, you have not received any evidence in this case, and you will not receive any evidence in this case unless you're selected for the jury. Does everyone understand? Yes. So if I were to ask you right now to vote on whether Mr. Aguilar is guilty or not guilty, what should your vote be? Guilty. That was a slow reaction. You don't have any evidence. So what should your vote be? Not guilty. Okay. So the burden of proof. Who has the burden to prove the case? The state does. The defense never has the burden to prove their client not guilty. The state has to prove their client guilty beyond a reasonable doubt. Does everyone understand? Yes. So what does that mean, really? That means that the state could play video games, go to sleep, do crossword puzzles. That's how all of our professors would explain it to us. And the reason why they said that, because they wanted embedded in us that the defense does not have to prove anything. You could go to sleep because you don't have to prove anything. Now, what I can tell you is, I don't think these defense attorneys will be playing crossword puzzles or going to sleep, but they don't have to prove anything. So if ever you're deliberating in a jury and you start saying to yourself, well, I wonder why the defense didn't bring this piece of evidence or why the defense didn't do this. You have just shifted the burden and you're not allowed to. Does everyone understand? Now, what is proof beyond a reasonable doubt? When I was in law school, everyone had to know the definition. I knew it forwards and backwards. I had my first jury trial. I was so proud of myself because I knew the definition. I didn't stumble. I paused for dramatic effect. I used the explanation and the commas where they should be. And after that first trial, guess what happened? There is no longer a definition for proof beyond a reasonable doubt. So neither the state nor the defense can tell you what proof beyond a reasonable doubt is because there's no definition for it. So when I was a defense attorney and a prosecutor, I said, well, I've got to explain it to people some way because I don't want them to be using the wrong burden of proof in a criminal case. So next door in the historic courthouse with the green rooftop, they charge civil cases. One of their burdens when you're dealing with money or car accidents, it's preponderance of the evidence. It means more likely than not, something happened. If you're ever on a criminal jury, whether it be in misdemeanor court or felony court, if you're in the back deliberating and you hear people saying, I think that happened more probably than not, you are at the wrong burden. You have lowered the burden. That is not the burden. Does everyone understand? Yes. Yes. The highest burden in Texas that they have on the civil side is something called clear and convincing evidence. It's the type of evidence that's needed to terminate somebody's parental rights where they say, you're a danger to this child. We're going to take away your legal right to be their parent. And your child is going to either be placed in foster care or with another parent. Does everyone understand?
Yeah.
All right. The state and the defense may talk to you about fairness and whether you're biased. Normally, I always hear this hypothetical. They say, let's assume you have jury duty. You get up, you're excited about it. You get up extra early. You already make plans. You know where you're going to park. And when you come downstairs, your car has been burglarized. The windows are broken. The radio is gone. Tires on flat. But good citizen that you are, you say, you know what? I am going to call an Uber or somebody. I'm still going down for jury duty. And then you find out the case that you are going to be sitting on is a burglary of a vehicle. How do you feel about that? Here's the correct question about fairness and bias. If your car has been burglarized and you end up on a jury, and that jury is for a burglary of a vehicle, will you listen to the evidence and make a decision on whether somebody's guilty or not guilty based upon the evidence that you hear in that specific case? Or are you going to say, my car was burglarized, so anyone who's charged with burglary of a vehicle, I'm just finding everybody guilty? So when we speak about fairness on the criminal side, what it means is, will you be able to listen to the evidence? Or are you going to use something in your past to say that someone is guilty because you're upset about something that happened to you? Nobody in this courtroom was born yesterday and slept all last night. So everybody has something in their past, in their history, that has been traumatic. Some people have had thefts happen to them. Does everyone understand? So is there anyone here who feels as though they cannot be fair? The next thing I want to talk to you about is there are two phases to every jury trial in Texas, the criminal side. The first phase, people like to call it the innocence phase, but it's really not that. The first phase is, did the state prove their case or not? So the first phase is guilty, not guilty, or we can't make a decision. That's phase one. In phase one, if you say that somebody is not guilty, there's no phase two, because phase two is the phase you get to if you find someone guilty, and it's called the punishment phase. In Texas, it's required that anyone who's going to trial on a criminal case make a selection on who they would go to if they were found guilty. It's required. It doesn't mean that the person is saying they're guilty, doesn't mean that they're saying they trust somebody and, trust one person and not the other. It's just an election they have to make. So in this case, Mr. Aguilar has decided if he were to be found guilty, he would come to the court for punishment. Does everyone understand? Yes. Is there anyone who's going to hold it against him because he has decided to come to the court for punishment if he were found guilty? Next thing I want to talk to you about languages. I love languages, as you can tell. The only thing my friends were able to really teach me, or that I paid attention to, is probably in almost every language I can say hurry up. So please raise your card if English is not your first language. You need to turn your card around. Oh, that's right. All right, so we have number 3, 22, 32, 33, 18, 50, and 59. 69. Thank you. All right, juror number 3. What is your first language? Spanish. Have you been able to understand everything?
Yes, ma'am.
Juror number 18, what is your first language?
Indonesian,
Oh, that is new. Have you been able to understand everything?
yes.
All right, how do you say hurry up? in your language?
Been so long, I left Indonesia, Cepatan.
Okay, all right, and you know, I know you're gonna have a hard time writing it down, Cindy, I'm sorry. Juror number 22, if you stand up, yes.
It's Tagalog, Philippines.
All right, have you been able to understand everything?
Yes.
All right, thank you. Juror number 32,
Spanish?
have you been able to understand everything? Thank you. Number 33,
Spanish.
have you been able to understand everything?
Yes.
Thank you. 50. And what's your first language?
It's fine.
Have you been able to understand everything?
Yes, ma'am.
Thank you. Number 69. And what's your first language?
Spanish?
Have you been able to understand everything?
Yes, ma'am.
All right, thank you. The next thing I want to talk to you is about time constraints and travel arrangements. This trial will most likely be completed maybe by Thursday or Friday. Is there anyone who has any time constraints where that's going to be an issue? And when I say we'll start this jury trial, we will start it tomorrow at 9:30 a.m. So if you have a time constraint, please raise your card. All right, 2, 8, 9, 10, 13, 14, 16, 18, 19. And when I call out your number, if you'll lower your card, 28, 30, 42, 43, 44, 55, 57, 65, 66, 73, 75, and we have a late person coming to the party, number 60?
Yeah.
Okay. All right. Juror number 2, what's your time constraint?
I have to drive my son to work. His car is broken. And we have to take him to his work and then get over here, and with construction and traffic, it's too much for us.
All right, and what?
In our 70s, and we
Okay, what time do you have to drop your son off?
between 5:30 and 6:30.
5:30 a.m. and 6:30 a.m.?
Yes.
And what time is the pickup?
No, we don't pick him up because he works until 9, 10 o'clock at night, so he finds a ride home.
All right, thank you. Number 8?
Right?
Yes.
They sold a company where I was at for 18 years, so, PT new people that ropes up opening the car lot and closing the car lot. But today they excuse me only for the day to be here, you know, cause I gotta open the shop at 8 o'clock and I don't close it till 5:30 in the evening.
All right, thank you.
Yes, ma'am.
Number 9?
So for a jury trial in Hidalgo County, starting Thursday morning, pre-trial begins tomorrow afternoon.
And what are you trying?
Car crash case.
Okay, all right, thank you. Number 10?
Mine would try to get transportation here. I don't drive. I'd have to find a ride.
All right,
I had
thank
to
you.
get my son to give me a ride today, so I wouldn't have a ride tomorrow.
All right, thank you.
You're welcome.
Number 13?
I plan to be in Houston for work overnight,
All right, what do you do in Houston?
sales for a chemical company.
And when is this?
Supposed to be there tomorrow, spend the night, come back Thursday.
All right, thank you. Number 14?
Have a work conference up in Dallas, so I have to leave there Wednesday, come back.
All right, and what is the work conference?
I work for a construction company.
All right, thank you. Number 16?
I work for a distribution center, and I work from 6 a.m. to 2 p.m. and my job only excuse me for that.
All right, thank you. So everyone, just so you know, employers are not allowed to not excuse people for jury duty. It's illegal for them not to let you serve. But thank you for letting us know. All right, number 18.
I'm an inclusion special education for high school,
Mhm.
and we're going to have unit tests for biology tomorrow, and I have to be there.
All right, thank you. Number 19.
I could reschedule it. It was an appointment at home.
All right, thank you. Number 28.
I have school tomorrow and Thursday.
Oh, where do you attend school?
Real estate school, but it's in person.
All right. Did you tell them downstairs that you had real estate school in person?
Yeah, they told me I had to come up here and talk to the judge, so.
Who told you that?
In the first room that we were in.
All right, thank you.
Yeah.
Number 30?
Yes, I work from 6 to 2. My daughter and I take care of my 95-year-old dad. So she works at night and I work during the day, and I do drive her to work out when I get out.
All right, and what time do you take her to work?
She goes in at 4 to 10. I go in from 6 to 2.
All right, thank you. Number 42?
I just have to pick up my son from school. I'm the only that drives at home. So I get out of work at 3:30 and I pick him up at 3:45.
All right.
So I have no problem coming in, but I'm the only one who can pick him up.
All right, who's picking him up today?
My wife had to take off work and she's using her PTO.
All right, thank you. Number 43?
I teach in a homeschool co-op, and so the parents pay me directly. And tomorrow I teach from 9 to 2.
All right, thank you. 44?
I'm a band director at Brennan High School, and we actually have a basketball playoff game tonight. Tomorrow I have a clinician that we fundraised for all day. And Thursday and Friday I have TMEA, Texas Music Educators Association Clinic. It's a really crazy week for me.
Thank you, but the school activity, I mean, don't they concentrate better when the band's not there?
I would love to send that email.
All right, number 55?
Yeah, it's not big, but I just have car insurance due in a week and I was not expecting it to go.
I'm sorry, you have what?
Car insurance due in a week and I wasn't expecting it to go someplace there.
Okay. Number 57?
I have a flight scheduled on Friday morning.
And where are you headed?
Telluride, Colorado.
And what are you doing there?
A friend's trip.
I'm sorry, what?
A friend's trip.
All right, thank you. Number 60?
I just work from 7 to like 7, so.
All right,
that's
thank
pretty
you.
much it.
65?
I am helping facilitate a softball tournament at a university beginning on Friday morning.
All right, thank you. 66?
I do the payroll on Friday morning for the company that I work for.
They're gonna find out how really important you are. Some people, I always say, are you indispensable? Payroll, indispensable. Thank you for letting us know. Number 73? I'm sorry, by what?
By 5:30 before security leaves.
All right, thank you.
And the father can't pick him up.
All right. 75?
Served in and I run my own clinic and I have a lot of patients that serve that I have service. Nobody that.
All right, and what type of surgery? I'm sorry? All right, thank you. All right, everyone, I'm gonna tell you 2 stories. They're both true. I understand that jury duty is an inconvenience. And I'm gonna tell you why I say it's an inconvenience. It's an inconvenience because if you don't regularly come downtown, you get lost. There are too many one-ways. The parking is expensive. And when you get to that light and you finally see where you're supposed to be and you can't turn because it's one way, and then in your mind, you're thinking there's no traffic. I could just turn here and get where I'm going, but you don't. And then when you find parking, then you're running to the building. We have rain, there's construction on 35, but when is there not construction in San Antonio? And you run downstairs and they tell you to hurry up and wait. And then after you hurry up and wait, then you get called to the 187th and you're out in the hallway and you're waiting. It's an inconvenience. Your country only asks 2 things of you. It asks you to do jury duty once in a blue moon, and it asks you to pay your taxes. So raise your card if you ever sat on a jury trial as a juror. So as you can see, that is not even half or a third of people on this panel. So that's all your country is asking of you. You can lower your card. Now, let me just tell you what I consider a sacrifice. My family grew up in a small town called Grand Cane, Louisiana. My uncle was super intelligent. All the teachers knew him because that was back in the day when you had small classes. So every teacher from 1st grade through high school knew every student, and they knew him. And so when the teacher had taught him all they could teach him, when he was too smart for them, they would pass him to the next grade. So of course, when his brother and sisters follow behind him, that's bad news for them because all the teachers say, we're expecting a lot out of you because of your brother. Well, he ends up graduating and the Vietnam War breaks out. And he has to go to my grandmother for her to sign for him to go off to war. And he tells my grandmother, there's nothing I can do here. There's no way for me to improve my lot in life, civil rights and everything else. So please sign this so I can go fight in the war. If you can imagine, that was her firstborn. And that was back in the day when there were 3 stations, ABC, CBS, and NBC. And NBC, you really couldn't count on because the weather had to be just perfect. If there was a light little breeze, you're going to get a bunch of static. And that was at a time when you don't have this 24-hour news cycle or 24-hour television. At a certain point, the television would go off, and you know it went off because they play the national anthem. And when it got to be high tech, you just have the flag blowing in the wind. There was none of this, let me get on the internet, let me email somebody. It was what we now call snail mail. My grandmother did have a phone, but the phone wasn't touch tone and it wasn't rotary. And I know the young people don't even know what a touch phone or rotary is, but it was the phone where you just pick it up and an operator answers it and you tell the operator who you want to dial. That's why they would have songs like Beechwood 45789, because you pick it up and you tell the operator, could I have Beechwood 45789? So my grandmother, the only thing she knew to put on the envelope for him was his name and his number. That's it. My grandmother was super intelligent, taught me how to read and write, but she only had a 6th grade education. So she signed for him to go to a place that nobody in the United States had really heard of. One thing she quickly realized is that you do not want anybody knocking on your door in uniform because that was bad news. So she would mail letters to him and wait for those letters to come back, and those letters would come back months later. So I always tell people that's what a sacrifice is. And when you see people who don't want to serve jury duty, but if it's Independence Day, Memorial Day, Veterans Day, everybody wants to raise the flag. What I can tell you, there is no longer a draft. Who knows? It may change. It hasn't. So your country is only asking you to take time out of your schedule, if you're selected for a trial, to be fair and to listen. Does everyone understand?
Yes.
Second story I'm going to tell you is about one of my friends in law school. She did civil law. I always loved criminal law. She got called up for jury duty. She wanted to have lunch. I said, that'll be fabulous. We started talking over lunch. I asked her, how's it going? She said, fantastic. Now that I'm a judge, I'm like, how could it have been fantastic? You were not with me. But I said, what do you mean it's going fantastic? And she says, I'm not going to be on the jury. I said, how have you figured that out? And she says, because it's just like law school. I'm on the back row and I'm not saying anything and I'm keeping my head down. So I start laughing and I tell her, this is going to be a great week for us. She said, why? I said, because we're going to have lunch all week because you're going to be on the jury. And she was. So other than raising a card saying, please select me, the quickest way to be on the jury is to remain completely silent. And I tell you that story, and it is a true story, but I tell you that so you can speak up because each side is going to have 30 minutes to get to know everything they can about you. All right, does anyone need a break? To the interpreter, do you need a break?
How much longer after this?
It's 30 minutes here and 30 minutes here. All right, thank you. All right, state.
Good afternoon, everyone. My name is Megan Galloway, and I represent the state of Texas here today. And so I have a confession to make to all of you. So I know when you all were on your way to work this morning, or to the courthouse this morning, I was on my way to work this morning. And so it's no secret about the construction that's been going on downtown. We kind of talked about it here today, but with the rain and everything, it was taking me longer than I anticipated to get to work this morning. And so I get on Cesar Chavez and it's going down to one lane, and somebody didn't anticipate that they were gonna have to merge in front of me. And I'm like, I'm sorry, I can't let you merge today because I have to get to work. And so I say that story to say to you all today, if you see me and you go, hey, that's not jerk, that didn't let me merge this morning, and you're gonna hold it against me, speak now or hold your peace. Okay, so let's talk about jury selection. It's like the judge said, I know you guys probably feel like you don't call on me, but the quiet ones are the ones that end up on the jury. And so if you don't speak, this is what you're gonna look like in panels. And look at how happy those people look to be sitting on the jury. So let's talk about the purpose of jury selection. Okay, so it's to talk about the law. It's like the judge said, we cannot speak about the facts that are in this specific case. And to learn about you, because our goal, the state's goal, as well as the defense's goal, is to get 12 fair and impartial jurors that are right for this case. So when I say right for this case, what do I mean? So who can tell me who that is? Willie Nelson, good job. What does Willie Nelson love? Yeah, right? And so let's say that Willie Nelson was called in to sit on a misdemeanor possession of marijuana case. What do you all think his verdict would be? Not guilty, right? Because he fundamentally disagrees with the law, and he has made this clear, and that's not an issue. But I'm gonna refer to something throughout my jury selection that I refer to as the Willie rule. And so that's, do you understand the law? Do you disagree with it? And can you follow it? Okay, and so when we are talking about finding someone that can be fair and impartial, that's what I really want to know. Can you follow the law as it's applied in this case? Because you're going to, if you end up on the jury, you have to base your decision based on the evidence, okay? And so I have this up here. I have a rule during my presentation of jury selection, and it's no waffling. Because sometimes we get jurors, and I refer to them as the little engine that thinks they can. Because when I ask them a question, they go, well, I think I can, and I'm sorry to inform you, but that's not good enough here. We're looking for yes or no answers. And I don't really care which way you answer, you just need to be definitive in your answer. Does that make sense?
Yeah.
Does anybody have any questions so far? Okay. And the reason for that is because if you end up impaneled and you are on the jury, like I said, you have to render a true verdict according to the law and the evidence. So if you have any qualms or disagreements, or you cannot follow the law, now is the time to let us know, because once you end up over here, it's too late, okay? Now, the judge kind of touched on this, the burden of proof. The burden of proof in a criminal case is beyond a reasonable doubt, and it rests on the state. So like she said, there is no legal definition, but I can tell you what it's not. It is not beyond all doubt. It's not beyond a shadow of a doubt, and it doesn't mean you're 100% sure. Because if you were 100% sure, does anybody know what that would make you in the case? A witness, right? Because you were there and you saw everything. That's the only way that you can be 100% sure. And so, who has ever come home to this? By a show of hands, the cards, right? Okay, juror number. I'm sorry, I'm picking on you. What's your number?
Yes, you are.
Juror number 7. Okay, can you tell me what happened in this illustration?
Oh, we can infer a few things.
Okay, what are those things?
The dog was left alone.
Uh-huh.
The carpet was left out and available.
Okay.
And it was looking, he was hungry.
Okay. And he's the one that made that mess, right?
But it might be in there,
Okay. What might be in there?
whatever he's looking.
Oh,
Or
okay.
she.
So So what you think, right, is that the dog's the one that got into the trash and made that mess, right?
Yeah.
Okay, and how are you able to know that if you weren't there to see? Exactly. Well, you said you're able to infer, right? from the
I
photo.
inferred from it, but that's all I do.
Okay.
I was not there.
And so when we talk about beyond a reasonable doubt, right, we're looking at the evidence, right? So is it possible here in this picture that somebody broke into this home and decided not to take anything from the home, but there's no signs of forced entry and they just came and tore the trash bag and walked out? It's possible, but that's not really reasonable, right? The evidence does not suggest that. And so that's what we mean when we're talking about the burden of proof and beyond a reasonable doubt. Does everyone understand that? Does anybody have any questions regarding that?
Did the dog do it?
And so based on my explanation of beyond a reasonable doubt, knowing that that's the standard, is there anyone here that says, you know what, that's not good enough for me? I would require the state to prove their case 100%. Like, would you hold the state to a higher burden than beyond a reasonable doubt? Yeah, okay. Juror number 30, you would hold the state to a higher burden?
Yes.
Okay, is there anybody else that agrees with juror number 30? All right. Now, I have a question that I want everyone to answer. I'm gonna read it to you and then I'm gonna ask, oh, juror number 55?
I feel like it would depend on the situation, but yeah.
All right, so if you all could please stand so that the court reporter can hear.
My bad.
Okay.
Yeah, I feel like it would depend on the situation, but.
Okay, that's kind of waffling.
Yeah.
Talk about it. So, right, they need a yes or no answer. Would you hold that state to a higher burden? That's, you're taking too
I'll just
long to
say yes.
answer. I feel like that's a no.
If there's an option,
What?
I mean,
All right, I'm sorry, you're gonna have to stand so the court reporter can hear.
yeah, I mean. If there's a situation, then I would say yes, so. Then yes,
So you would?
yes.
Okay, thank you. Okay. Moving on, so this is a question I want everyone to answer. I'm gonna read it to you and then I'm gonna ask you to select what number you most align with. And when I ask you, I'm gonna ask you to raise your hand and not put your card down until I read off your number, okay? So it is, what is your opinion of the criminal justice system? Choice number 1, you think it's terrible and it takes away our rights. Choice number 2, you think it's concerning because it interferes with our rights. Choice number 3 is you think it's helpful and looks out for citizens. And choice number 4, you think it's beneficial and protects us from the harmful actions of others. So who here most aligns with choice number 1 and think it's terrible? Juror number 67. Thank you. Okay, who aligns most with choice number 2? You think it's concerning? Juror number 15, 16, 21, 25, 48, 52, 55, 44, and 74. Okay. 48. Choice number 3, you think it's helpful and looks out for citizens. Jurors 2 through 4. Jurors 6 and 7. Jurors 8 through 14. Juror 18. Juror 26 through 29. Jurors 32 through 36. Jurors 37 through 43. 45 through 47. 51, 56, 57 through 60. 61, 62, and 64. 65, 69 through 72, 73, and 75. And then who aligns with choice number 4? Jurors 1, 5, 17, 19, 22 through 24, 30, 31, 49, 53, 54, 63, and 68. Now I want to talk to you about a multi-count indictment that, like the judge said, the indictment is the means by which, 66, yes.
I feel that I need to be excused because I have a hearing problem and one of my hearing aids is not working and I wasn't able to hear what you were saying there.
All right, what is your number?
66.
All right, thank you so much for letting us know.
So as the judge stated earlier, the indictment is not evidence of guilt. It is the vehicle that the state lets the defendant know what they're being charged with. There is such thing as a multi-count indictment. And so that is a means where a defendant is charged with multiple offenses through the same indictment. And so in this case, we are talking about aggravated assault with a deadly weapon, and it's going to be 3 counts of that. And so I want to talk to you about the elements. The elements are what the state has to prove beyond a reasonable doubt. So that's on or about the date that the offense occurred in Bexar County, Texas. The defendant did intentionally or knowingly threaten imminent bodily injury to the victim and did use and exhibit a deadly weapon. That in the manner of its use or intended use is capable of causing death or serious bodily injury. So that's a lot. We're going to kind of go through it piecemeal. So let's talk about the mental state. In this case, it was intentionally and knowingly. So intentionally is the defendant's conscious objective or desire. So when I think of it, I think, did the defendant mean to do that? Knowingly, it means that the defendant acted and he was aware of the nature of his conduct. So when I think of that one, I think, did the defendant know what he was doing when he did that? And so regarding the mental states, you are not required to be a mind reader. The law says that you are able to infer this from words, actions, and circumstances. So I want to do a hypothetical, and we're going to do a hypothetical with the movie Titanic. Now, if you've never seen this movie, it's fine. I'm going to tell you everything that you need to know. Okay, so there's 3 characters at play here. Hal Hockley, Rose DeWitt Bucator, and Jack Dawson. Okay, and so in this hypothetical, we're going to look at the circumstances to determine Cal's intent. So 1, Cal grabbed the firearm from his personal attendant, and Cal starts shooting that firearm at Jack and Rose. There are many other people that are in the crosshairs, but Cal chases Jack and Rose and continues to shoot until the magazine is out of bullets. So who can tell me what was Cal's intent? What did Cal mean to do when he was shooting the firearm at Rose and Jack? Hurt of bodily injury. What's your number? 90. Okay. Can you raise it, please? Okay, what was your answer? Bodily injury. Bodily injury. At a minimum, right? I heard some other people say he was intending to kill him, and that's good. And so, did Cal know what he was doing when he did that? Yes. Right, based on the circumstances, right? And so, I have this up here, and it says Rose and Jack did not get hit, right? They didn't get hit by a bullet. Is it still an aggravated assault with a deadly weapon?
Yes.
It is. Good job. Very good. And the reason for that is because we're going to focus on those 2 elements, which is a threat of imminent bodily injury and the using and exhibiting of a deadly weapon. That is what makes an ag assault, right? And so imminent means near at hand or impending, and bodily injury is defined as physical pain, illness, or any impairment of physical condition. And so under the law, the victim does not have to sustain bodily injury for the offense to be completed. There just has to be the threat of that. And so is there anyone here that says, I don't agree with that law? I think that the victim should have to sustain bodily injury. No? And I have this question up here, and does a threat have to be verbally communicated?
No.
No. Does anybody think, yes, a threat does have to be verbally communicated? No. So we'll talk about deadly weapons. So a firearm is per se a deadly weapon, right? But I want to focus on that third thing, and it says anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. And so we're focusing right on in the manner of its use or intended use. So I want to give you a hypothetical about a pillow. Let's say that there's two college roommates and one takes a pillow and hits the other one with a pillow. Is that in the manner of its use a deadly weapon? No, right? Let's say that one roommate takes a pillow and smothers the other one. Is that in the manner of its use a deadly weapon? Okay. And so I have this question, is a motor vehicle capable of causing serious bodily injury or death? Yes. Yes, right. And we don't have to look far to know that, right? It's an important issue for TxDOT when we're driving on the highways. They're always making sure that we have our seatbelts on and are not driving intoxicated. And if you turn on the TV, you can see people that have been charged with intoxication, manslaughter, and other offenses like that. But does anybody disagree with that law? Does anybody think that a motor vehicle cannot be a deadly weapon? No. And so what type of evidence would you all expect to see in a case in a court? I know that a lot of people watch, CSI Miami and other Law and Order shows and kind of have this heightened idea of what evidence should be. But does anybody want to throw out any answers of things that they would anticipate to see? Number 5.
Surveillance.
Surveillance, that's a good one. Number 4.
The weapon?
Okay.
Video.
Video, okay. 40.
Photo evidence.
Photo evidence, that's a good one. 14.
Picture.
Okay, right.
Excuse me. If you could make sure, everyone, that you keep your voice up, because the court reporter will not be able to hear.
So Juror, what was your number?
Witnesses.
Oh, your number, sorry.
14.
14. Okay, so he touched on what I was looking for. So all of you guys have good answer, photo, video, but he really touched on what I was looking for, and that's witnesses. Because testimony is evidence, right? And so throughout the trial, you may hear from a number of witnesses, police officers, lay witnesses that were there and observed it, the victims. You couldn't even hear from the defendant or any defense witnesses. And so you all are the exclusive judges of the facts that are proven, the credibility of any of the witnesses, and the weight to be given to any of the testimony from the witnesses. And so I have a question regarding this. Would anyone hold it against a victim if they do not speak English? No? Okay. And so we kind of went over this with Judge Boyd, right? She said, you have no evidence right now. So having heard zero evidence, you would have to vote not guilty at this point. So I have this. Who can tell me who this is? You guys are really good. So I put this up here because at the point in Mulan, she sings this song called Reflection. And the reason I have this up here is because in the jury trial, you may see the defendant and think, hey, he reminds me of my father, my brother, my cousin, or my friend. But you are going to be charged that you cannot let sympathy play in your deliberations. So my question to you all, is there anyone that cannot set aside their sympathy and render a fair and impartial verdict? No? Now I have this question regarding law enforcement officers. So what is your opinion of law enforcement in Bexar County? 1 being you do not like them at all, and 4, you think that they are beneficial. So I'm going to ask you to think about where you are on the scale, and then ask you to raise your hand. So who is with number 1? You have a poor opinion of law enforcement in Bexar County. 67. Okay. Is that based on a personal experience or just someone you know? I'm sorry.
Should I say?
Yes, can't hear you.
No.
Okay. But so what is it? Is it based on a personal experience or an experience of somebody that you know?
Education?
Okay. So would you be able to set that aside and, listen to the testimony of the officer and assess his credibility on the stand? Or would you discredit him just based on him being a police officer?
Yeah, I'll say this.
You would, okay, so you wouldn't be able to give him a fair shake. Okay, does anybody else agree with, juror number 67?
I bring up number two, cause I know where he comes from, cause when I got prosecuted, I had an officer that was trying to lie, getting prosecuted.
Okay,
And my judge actually sat him down and told him case dismissed, cause the evidence didn't match with the evidence that we have on paper.
okay,
So I would have to go with it.
with you.
Yes.
Okay, so based on, this personal experience that you had, would you be able to set that aside and not hold that against the officer that's testifying in the trial?
It would be hard. I'm not gonna lie.
Okay, so you wouldn't be able to set it
It
aside.
would be hard.
Okay. You wouldn't be able to set it aside. Okay, thank you. Okay, so who is a number 2 on the scale? 44, 48, and 55, and 25. Okay, keep your cards raised. I have the same question for you guys. Would you be able to set aside your view of law enforcement and render a fair and impartial verdict?
Yes.
Can you raise your card, please? Okay, so you would be able to assess the credibility of the officer and not discount him at all?
Yes.
Okay. Juror number 48,
Yes.
you would be able to disregard your personal views?
Yes.
Okay. Juror number 44,
Yes.
you would be able to disregard your personal views?
Yes, ma'am.
Okay. Juror number 55,
No.
you would not be able to. Thank you. Okay, on the scale, who's 3? There's 4, 5, 3, 9, 11, 13, 14, 15, 16, 19, 23, 24, 28, 30, 32 through 34, 36, 40 through 42, 37, 45, 49, 50, 52, 56, 57, 58, 60, 61, 65, 71, 72, 73 through 75. Okay, and who is on number 4? 1, 2, 6, 7, 10, 12, 17, 22, 26, 27, 29, 31, 35, 38, 39, 43, 46, 47, 51, 53, 54, 59,
54. 59.
62 through 64, 68, and 69 through 70.
I want to add one. Yes.
Okay,
I think law enforcement is important.
You would be on which
4.
number? 4? Okay, thank you. All right. And what was your number? 18. Okay. And so the judge kind of talked about this earlier. There are 2 different phases in the trial. The first is guilt innocence, and that's when you're deciding whether the defendant committed the offense or not. And then the second part is punishment. So in guilt innocence, we're only looking at the evidence and the elements of the offense. And punishment, other things can be considered. And so I want to talk to you about a possible defense, and that is voluntary intoxication. The law in Texas is that voluntary intoxication does not
5 minutes. 5 minutes.
does not constitute a defense to the commission of a crime. And so what that means is if a defendant chooses to ingest a substance that makes him intoxicated, he cannot come back and claim, oh, well, I didn't know what I was doing, because that does not negate the elements of intent or knowledge. And the defendant is guilty even if they have no recollection of the offense due to intoxication. Now, does anyone disagree with that law? Will you roll? Okay. And so, like the judge informed you, the defendant has elected to go to the court for punishment. Is there anyone who would not be able to fairly consider the evidence because they are not going to be deciding punishment? Does anyone here have a family member or someone that you know that was prosecuted or convicted of a felony and feels that that person was not given a fair shake in the criminal justice system? You can raise your hand. You're number 8. We already talked about it, right? Your brother as well. Okay. Would you be able to set that aside?
Yeah, I would.
Okay. Juror number 15. Oh, okay. Juror number 16. Would you be able to set that experience aside and render a fair and impartial verdict in this case? No? Okay. Juror number 30. Would you be able to set that aside?
Yes.
Okay, and you could disregard that and render a fair and impartial verdict in this case.
Yes.
Juror number 68. Would you be able to set that personal experience aside and render a fair and impartial verdict? Okay. And juror number 74. You would not be able to set it aside. Okay, thank you so much. And is there anyone here that is not able to sit in judgment of another due to any personal, moral, or religious reasons? What's your number?
8.
Juror number 8. Okay, anybody else that feels that they cannot sit in judgment of another? All right, well, that's all I have for you. Thank you guys so much.
All right, so ladies and gentlemen, we're actually going to take a short break at this time because the interpreter needs to take a break. So nobody is allowed to remain in the courtroom. Please leave your numbers behind. And before I have a seat, have a seat. You're rushing. All right, look to your left. Look to your right. You are responsible for that person that you looked at. So I'm gonna have you all back here at 4:15. And please, wait a minute, everyone, please make sure you're lined up by 4:15. If you need to use the restrooms, it's near the stairwell. So everyone, please rise for the jurors.
Please keep your number behind.
Oh, very good.
Excuse me, Judge. Is there any way we might be getting out of here for me to make my basketball game?
So, I'm sorry, I'm not allowed to talk
Not allowed
to
to
you.
talk? Okay,
Yeah,
sorry.
so, no problem. You can expect. Oh, thank you.
Perfect, thank you.
Ready? Yes.
Okay, number one.
Let's take this. Can everyone please be seated? All right, and everyone, we have a new interpreter. Usually interpreters are changed out every 20 to 30 minutes. All right, defense, are you ready to proceed with your voir dire?
Yes.
All right, you may proceed.
Fearless. I'm Megan Enriquez. A lot of I do have a PowerPoint kind of to guide me along, but a lot of it's on the PowerPoint going to be redundant from what the judge has already talked about and what Miss Galloway has already talked about. She's Megan now and Megan Enriquez. It's a little confusing, so I'm gonna call her Miss Galloway. But really, I just want to hear from y'all. Y'all have heard about the law. Everyone's saying they can be fair. I just want to get to know y'all. I want to learn about your preferences, your opinions, some of the rules of the court. We can't talk to you outside of this space right now, around 30 minutes. So after these 30 minutes, if I see you in the hall, I can't talk to you, the judge can't talk to you, they can't talk to you. So I want to hear from you right now. I don't want this to be like my first date. My husband said that I talked the entire time and he didn't say a word. So I want to hear from y'all, okay? So one way, an icebreaker that I have is bumper stickers. I think that bumper stickers, if you have them, say a lot about you. I have a small decal that says SMU. That's where I went to undergrad. That's the only thing I have on my car. Does anybody here by show of number have a bumper sticker on their car of any kind? You're number one. What is your bumper sticker?
Texas A&M University.
Okay. 8. Okay. What rank? Okay. 14. Oh, your family crest? Very cool. What is that?
Oh.
I'm so sorry. Could you keep your voice up?
Oh yeah, it's like 2 lions that has a Latin. Yeah.
Very
Like some
cool.
phrase in there.
I'm pregnant with my 3rd child. I kind of want like a bumper sticker with the family, like the husband, the wife, the 3 kids, I have 2 dogs. Just like, oh, just hey, it's chaos, you know. Or like the bumper sticker that says, I'm not drunk, I'm handing snacks to my toddler. That's me. Usually handing applesauce or getting applesauce thrown at me. Yeah. 29.
Texas A&M.
Okay, cool. 19?
My daughter's school.
Okay, UT? 41?
The state of Texas, the company that my husband and I own.
Okay, very cool. So is it like a marketing decal or?
Yeah, the race seal company.
41? And what does the company do?
The race fuel company.
Okay, very cool. 37?
St. John Fisher College,
Okay, is that where you went to school?
Yes.
Okay, where is that?
upstate New York.
Very cool.
Rochester.
Are you from San Antonio or from New York?
I'm from New York,
Okay, what brought you to San Antonio?
work,
What do you do for work?
work for the Department of Defense down here,
Okay. Neat. How long have you been in San Antonio?
about 3 months.
Oh, very new, cool. Welcome. You have 70 new best friends, 39.
Right.
Right, okay, I like that. 52?
US Army,
Okay, are we in the army?
I'm going in next week.
Okay, wonderful, thank you for sharing. 72?
I have anime stickers and the animes that I like.
Like your favorite characters?
Yes.
Super cool, okay.
It's
71?
actually a window decal, but I goes with all that. It's blacked out, my card is blacked out, so you don't see it up close, but it's just a softball, baseball, basically, make it fun.
Very cool. Cool, okay. Well, I like that. See, that is a nice icebreaker. Fun way to kind of get to know you a little bit. Okay, presumption of innocence. As the judge touched on, Ms. Calloway touched on. If you had to vote guilty or not guilty right now, Mr. Edgar Aguilar sits here today, who would vote guilty by virtue of him sitting in this chair? Anyone, by show of pardon. Who would vote not guilty? Why? Who wants to volunteer why, as he sits here today, he is not guilty? Number 40.
There's no evidence of anything.
You have no evidence, and everyone said, as Judge Boyd said, we could sit here and play solitaire and do crossword puzzles, not lift a finger, sleep, take a nap. I kind of want to take a nap. But we can do absolutely nothing. And if they don't prove the case to you, you have to vote not guilty. And when I say prove the case, prove each element, and Ms. Galloway went over the elements for what he is charged and on trial for here today. Each element. So in Bexar County, Texas, well, that's an easy one. You know, that's probably to be proven. Something happened in Bexar County. That it was Mr. Aguilar. Okay, so some of the elements aren't going to be in question. Some of them are. And each one has to be proven beyond a reasonable doubt. Every single one. So if one of those elements you have a reasonable doubt about, not guilty. Even if they've proved all the other ones. If one is missing, for instance, if they don't prove it happened in Bexar County. If there's not a witness that stands up there on that stand and says it was on yada yada road, that's in Bexar County. If they don't prove that, he's not guilty, even if they prove all the other ones that seem more important. Everyone is that important, okay? So, I'll give you another example, kind of as he sits here today. My very sweet mother, who I adore. My dad and I like to give her a hard time. We call her Shirley. Why do we call her Shirley? She loves to jump to conclusions. Shirley, because he's sitting here today. No Shirleys, okay? He is presumed innocent. So we don't get like Don Enriquez, very sweet Don Enriquez, Shirley because yada yada, or in Spanish, it says like, oh, his last name's Garcia. You must be of the Garcias that live down the street, blah, blah, blah. It's like, why would you make that? Garcia's such a common last name. Well, it's like Shirley, blah, blah, blah. No Shirleys, okay? Have to be proven. Instead, I want each of you to be the high school job. It's like, prove it. Every single element. Prove it, you know? Was it intentionally or knowingly? Prove it. If they don't, he's not guilty. Every single element. The other thing is, for what he is charged with. So, I have an example of this. Let's take this and come back. Okay. So I'm gonna play a little clip. As you watch this little clip of this music video, I want you to think to yourself during this 28-second video, what is this video evidence of? What should she be charged? Does anyone know who this is? What has her name? Does anyone like Carrie Underwood? No. Raise your hand if you like Carrie Underwood. You're fine. 1, 2, 12, 14, 30, 28, 29, 33, 38, 39, 41, 43, 45, 49, 51, and 68. How many of y'all like country music? Okay. So lower your card if you already said Carrie Underwood, but if you're a country music fan but not a Carrie Underwood fan, raise your hand. 10, 5, 13, 7, 16, 17, 26, 27, 30, 31, 23, 40, 46, 52, 54, 73, 70, 65, 63, 59, 58, 57. Has anyone been to the rodeo this year? 9 and 30, 27, 23,
Going this week.
9, 30, 27, and 23. And then
I'm going this weekend.
29 is going this weekend. Anyone have plans to go to the rodeo like 29? 70, 73, 74, 72, 26, 24, 22, 30, 33, 37, 46, 52, and 13, and 3. Okay, so now I'm going to play the video.
Non-trans bitch probably getting thirsty right now. Probably buying her some fruity little drink, cause she can't shoot the whiskey right now. Probably up behind the whip.
Okay, raise your card if you know what crime you think she should be charged with in the 40.
Vandalizing personal property.
Vandalizing personal property. 63.
Destruction.
Destruction. 29. Did you
That was destruction of property.
Okay. Anyone else?
Vandalizing.
Yeah. And all those here in Texas, we call it criminal mischief. So I'm going to play another tiny clip, and you tell me what kind of evidence this is, what type of evidence, what this would be called. Andrew, you probably know the answer. That call for you.
Self-incrimination.
Okay, what do we call that 13? Starts with a C. 44.
Confession.
A confession. I dug my key into the side of his whatever, blah, blah, blah. I did this. I did that, right? So that's a confession. The criminal mischief. But what if she shows up to court and it's like, state of Texas v. Carrie Underwood for assault or for robbery? Would y'all say guilty or not guilty?
Not guilty.
Right? But it's her. She's on video. There's a surveillance video. There's sunglasses, but you can tell it's Carrie Underwood. Then they have a confession. She said, I did this. I slashed his tires. I broke his headlights. I did something bad. I did wrong. I dug my name in his seats. She confessed, but did she confess to assault?
No.
Did she confess to robbery?
No.
Did she confess to harassment? No. So if she weren't charged with criminal mischief, she'd be not guilty, right? Even though she might be guilty of tons of other things, 10 other things, whatever. You get creative. Okay. So just because someone is guilty of something And everyone agreed they have to be guilty of what they are charged with and what they're on trial for. So another example, back to the elements, so they have to prove every single element. In my example of the criminal mischief, what if the victim in this case, the owner of this truck, that she confessed to damaging, say he skips town, prosecutors are calling him, hey, Carrie Underwood's ex-boyfriend, we need to know what the damage was to your vehicle, we need to know how much damage was sustained, so we know what level of criminal mischief to charge her with. And he's like, I'm in Florida with my bleach blonde tramp, sorry. Like, slick, you know. Well, they're like, well, it looks like maybe $3,000 worth of damage, maybe we should charge her with a state jail. But, so then you get here, you sit in this jury, and they're like, so we have to prove for state jail felony that the damage was between $2,500 and $30,000. No receipts. No testimony of who, from the person who, from the body shop who fixed his vehicle. You have no evidence of the amount of damages. Well, they're missing an element. Even if you know it was Carrie Underwood, even if you know she damaged, even if you say she is on trial for criminal mischief. No, it was her. She admitted to doing it. But you don't know how much the damage was. That's missing an element, and she is not guilty. Even though she said, I did it, I broke the headlights, I keyed the car, I keyed the seats, I did all this. If you don't know what the level of damage was, and you can't even assume the lesser, because we don't even know without a receipt or some testimony that it was $100 worth of damage. We assume that, but you can't assume. You can't assume because, well, I know vehicles, I've had a headlight fixed. No, you cannot guess. No Shirley's, every element for what the person is on trial for. They need to prove it. If they can't prove one of the elements, the only just verdict, even with the confession, even with surveillance video, even with, you know, they're guilty of something, is not guilty. So I'm going to go back to one of the slides that I skipped. This one. Everybody in this room has a Fifth Amendment right not to testify. I know the judge touched on it. But will anybody hold it against Mr. Aguilar if he doesn't take the witness stand and tell you his side of the story? How many of you say, I want to hear from him, I want to hear what happened, I want to hear his side of the story? Keep your heart up. Y'all want to hear it, but who says, I understand I want to hear from him, but I understand he has the right not to. And even though I want, so who's saying I need to hear from him, or I can't find him not guilty if I don't hear from him? Do?
Well, for me personally, I would like to see his face, his eyes. You can tell a lot in that department. If
Okay.
he's telling the truth or lying.
So you'd have a hard time reaching a verdict if you don't hear from, if he doesn't take the stand and tell his side of the story.
Probably.
Okay, I'm gonna take Megan's rule, no waffling, yes or no?
Depends on what, no,
It's
it
okay.
depends on what he did.
So
And
there's-
the emotions on his face, his eyes, you can tell a lot on that.
Okay. Number 4, was your card up?
Originally for what I want to hear from him,
Uh-huh.
yes.
But you don't need to.
I don't
because of
need
the
to.
Fifth Amendment, right? Is anyone here that needs to hear from him before they could reach a decision? 25? Okay. Anyone else? Can anyone think of some reasons why a person would choose not to testify?
Being nervous.
Being
nervous.
What, number 10 says, yeah, they might be very nervous.
They'd be misunderstood. You won't read them right because of the tension
that they're feeling in the room, especially if they can't speak our language and we can't understand them and they can't understand us. So I feel they might come across wrong, so we would misinterpret what they're trying to tell us.
Yeah, that's a lot of really great reasons. Number 8.
And mainly like she was saying, mainly when the family or the person that you're in charge of that family, they're trying to looking at you and everybody looking at you. Well, you know, anything you don't want to or answer you're not supposed to.
Sure.
And that makes it will make the case go more against you than for you.
Okay. Anyone else? 16?
Feel like you don't need to.
The what? I'm sorry.
If you feel like you don't need to, because like all that evidence is there.
Right. Yeah, so because they need to prove it, right? Kind of like Judge Boyd said, we could all, the 3 of us over there could take a nap. And if they don't prove it, then he's not guilty, right? So yeah, that's a great point. You don't feel like you don't need to. Anyone else? I saw some other cards. 53?
Because lawyers ask them not to testify.
Exactly right. No one ever comes up with that one. Because his counsel advised him not to, for whatever reason we come up with, right? But most lawyers are gonna advise their client not to, for a lot of the reasons that some of these folks said. Number 9,
Maybe the trial's going so well for his side that at that point he chooses it's anything he said is not gonna, can't make it any better for them, so he chooses to stay silent at that point.
that's a great reason. Anyone else? Yeah, those are pretty much all the reasons. Okay. Beyond a reasonable doubt, beyond a reasonable doubt. So as they talked about, there are all different burdens of proof in our legal system. Beyond a reasonable doubt is the highest burden. The highest burden. And Megan said it's not beyond all doubt, or you feel it, because you know for sure beyond all doubt. But beyond a reasonable doubt, if you have reasonable doubt as to, again, and we emphasize this, one of the elements, just one of the elements, it is not guilty. Even if that's what it happened in Bexar County, Texas, even if it's on or about the date, whatever. What, or if it was something big, like, oh, it wasn't him, or the mental state, whether it was intentional or knowingly, or whether the complaining witnesses in this case were threatened with serious bodily injury or death. If one of those is not proven, he is not guilty. Not all of them. A reasonable doubt about one of them.
Can I say something? I disagree though, if there is a witness, then we have to prove, yeah, will be guilty. That's what I was thinking.
What do you mean? If there was,
I don't know, I'm watching too much SVU, especially. And I feel like sometimes the bad guy can go if they have really a good lawyer. But if there is a evidence, you're supposed to find guilty.
you're supposed to find them guilty if
Yeah.
there's evidence.
And
What if the
witness.
evidence doesn't prove
And a
every
witness.
single element? So kind of like in my Carrie Underwood example, there's evidence that she did something wrong, right?
But that one is, I cannot relate because that is a actress singing. And the scene can be made up.
Sure, but let's just, for example, for sake of the example, because I can't talk about the facts of this case during this part till the trial starts, unfortunately. So I'm just using that as an example, like, if that were the evidence, right? There is evidence, right, that she did something wrong. Let's assume that that's real, that really happened, that it's not an actress, right? If that was a real surveillance video at the beginning, you see who it is, right? Most people, a lot of people in this room could identify who that was. You see her committing a crime, so there is evidence of a crime. But what if she were not charged with the right crime? That was my example. So, like, the crime that she committed, my opinion, criminal mischief. I think that the state would be able to prove a case of criminal mischief, again, if they had the damage element as well. But if she were charged, if she were on trial for an assault, well, you would have to say not guilty, right? Would you say if she were here and she were sitting in that chair
And then I
And the
watched.
charge was assault. Would you find her guilty
Assault, based on that,
based on that video, based on that evidence?
not
And
to
the
human,
confession.
yes, but it's violence, yes, hitting the car, break somebody's window.
So you would find her guilty, no
Yes.
matter what she was charged with?
Yes.
Okay. Does anyone else agree with juror number 18? That no matter what Carrie Under was charged with, because there was evidence of a crime, she's guilty of whatever charge they brought against her. Anyone else agree with number 18? Okay. Does anyone else have just anything that hasn't come up in the judge's questioning, in Ms. Galloway's questioning, or in my questioning that they want to share? Anything about the chart? Yeah, 38.
Well, at the beginning, it said, the third offense. And so I would find it very hard for me to say not guilty if this is the third offense.
What do you
Because
mean by
there's
third offense?
Third count, not
the third count.
offense. It was just to
The third count. This is the third time being
No.
tried for the same thing.
No. This is not anybody's third offense. We're not going into anybody's.
No, but
criminal
at the
history.
beginning on there, it said aggravated assault with a deadly weapon ×3.
Oh, okay, and so this is when she was talking about a
Right.
multi-count indictment.
Right.
It's not a third offense, so let me just clear this up. A multi-count indictment. So say Carrie Underwood had damaged her boyfriend's car, her boyfriend's mom's car, and his daughter's car. They could all they're all parked in the same driveway. They could, on the same indictment, because all from the same day and they all the same course of conduct, that would be 3 charges, but all from the same incident. So, for instance, if I had a knife and I pointed it at these 3, it's nothing about my criminal history. They could, on one charging instrument, put that I committed aggravated assault against juror number 5, juror number 6, and juror number 7. Does that make sense? So that wasn't like
That wasn't.
that
that
he
wasn't-
committed 3 ag assaults.
Yes, because then I would find it very hard if this is the third offense and then to let them out again, and then something would happen, I would think, okay, this is on me now because
5
I
minutes.
said not guilty.
Okay, no. So just to be clear, no one is going into anybody's criminal history, so no one
No, I
knows if
just-
he's
I
done
just-
it once or twice.
Right.
So the 3 things is all from the same
Okay.
conduct, okay, all from the same time, the same allegation. If that makes sense, like my example here, or the Carrie Underwood example. Does everyone understand that? Everyone knows we haven't talked about anybody's criminal history or anything like that? Okay, everyone understands the multi-count indictment? Okay. Anything else like that, if you need clarification or something that you didn't quite understand, that's a great example, and I'm glad we cleared that up. Anybody else have any questions like that about the law, 65?
This may be a purely procedural question, but going back to your earlier example of the boyfriend skipping town, would he be charged with contempt of court in that case?
Judge Boyd? If you were served with a subpoena, the sheriff's in theory could go pick him up and bring him to court. But, I mean, sometimes the state has trouble finding their witnesses or something like that. Sometimes witnesses don't answer the phone. Sometimes they can't find contact information or whatever. So my point was, if they couldn't prove the damage, because that example, he skipped town, no, he very unlikely. Anyone else? Any other questions, hypotheticals? We'll go on 2 minutes. Anything that's come up? Any preferences, biases, anything that you want to talk about? Opinions on the law, opinions on the charges that we've talked about, anything like that? 39?
We talked before, about law enforcement and I don't know if this is the right time to ask the question. Will there be police officers testifying or witnessing?
I don't know
Okay.
who the state intends to call, but it is possible. And why do you say that? Because of your opinion, a bad experience or a particularly good experience?
Law enforcement in the family, I mean, tons of them.
Okay, because you have lots of members of
Yes.
law enforcement, so you think that maybe one of your family members could be a
No,
witness?
I don't know, no, they're all up northeast, but
Oh,
I do
okay.
have a lot of family that are cops.
Okay, and so because you have family members that are police officers, if a police officer were to be called to the witness stand, do you think you would automatically believe or find them more credible?
Yes.
Okay. 42?
So I just have a bias. I've grown up with convicted a murderer and a convicted aggravated assault uncles. So I can't say, I don't see him as guilty, but I can't honestly say that I wouldn't be easily swayed once I see evidence.
Okay, and so because of your family members, you wouldn't be more favorable to the defendant, you might have a bias against the defendant.
Just because I've grown up with it, yeah, with those types of people.
Well, thank you for sharing that. And 43, you were kind of nodding along whenever 39 was talking. Law enforcement, if you think they would tend to be more credible
Yes,
just
I
because
would.
they were wearing a uniform? Okay, anyone else agree with 39 and 43? Anyone else have an opinion or some sort of preference one way or the other that might be relevant to this case or to Ms. Aguilar or anyone that you'd like to share? If there's something that hasn't come up, or maybe you're thinking, well, I do, but I don't really want to say it in front of a whole courtroom full of people right now. If there's something that you'd like to talk about in private, maybe something like, juror number, I'm sorry, with the uncles, 42. Juror number 42 was comfortable sharing that about his family, but if there's something like that that you'd like to share that you think is important for us to know, and you haven't yet, and you don't want to say it in front of these people, would you raise your card? You don't have to say what it is, but we might call you back in private, not in front of everyone. Is there anybody who wants to share anything like that?
I have something. My thing would be,
Okay.
like you keep saying that they have to prove everything. If they can prove all of it but one, I might have a hard time with that, depending on what it was, to be honest with you.
No, thank you. for being
Because
honest.
I still feel that he was guilty for all of these, but not that one they couldn't prove. I would probably go strongly still feeling that he was guilty.
Okay, and
I mean, that's just being honest.
No,
And
thank
but
you.
I don't know if I would feel that way if I could hear everything, because we're only
Sure.
hearing part of it. But I'm just letting you know, if that scenario came up, that would be, I would have a problem with that.
All right, that's time.
That to find him not guilty if he was guilty on more, more than one or two.
All right, so that's time.
Okay, and 55. Thank you. Thank you for your time.
All right, so just on a final note for everyone. I heard a juror say something about it would be on them. Let me just, yes, juror number 38. Let me just explain something to everyone. If you ever are selected to sit on a jury, you have one job, and you're listen to the evidence that's presented to you, period. That's it. That's all your job is, to listen to the evidence and to make a decision on whether someone is guilty or not guilty based upon what you hear, if you can come to a decision. Does everyone understand?
Yes.
The state has the burden of proof. They have to prove every element beyond a reasonable doubt. And guess what? If the state has 6 elements to prove and they only prove 5 in your eyesight, and there is a 6th element that they don't prove, then your verdict should be not guilty. And there should not be a feeling of remorse, a feeling of, oh, this is my fault, because you're not the attorney. Both sides want a fair jury. All they're asking of you is to listen and keep an open mind. That's all that's going to be expected of you. Does everyone understand?
Yes.
So this is what's going to happen now. I need everyone to leave their numbers on your chairs. I'm going to have you wait in the hallway, and we're going to bring you back and you'll know who will be on the jury panel. Make sure you take your personal items with you, but you are not excused. So please do not have me on the phone having the deputy go pick you up from the Riverwalk. I know the Riverwalk is beautiful, but don't do it. All right, everyone, please rise for the jurors. You're good. Yeah, let me forget. I always tell people, don't worry. You wanna take the break?